Let's proceed to the principles of European contract law or PECL. PECL are a comprehensive set of rules and principles that aims to harmonize contract law across European jurisdictions. So they are developed by the Commission on European Contract Law, composed of a group of lawyers drawn from all the member states of European Community under the chairmanship of Professor Olilando. So PECL are also considered as a soft law, meaning they are not legally binding or directly enforceable regulations. However, they hold significant weight in the court. So, where they serve as a reference point for legal practitioners, scholars, and courts in European countries when interpreting and applying contract law. So let us proceed to the application of the PECL. So PECL may be applied only to international sales contracts that are connected to Europe. So it's primarily designed for the contracts within the European community. So if it's going to be applied to a contract of a non-European state, it may be not applicable to the laws or rules within their jurisdiction, since this is aligned to the contract law across the member states of the Europe. So according to Article 101 of the PCL, the point here is that PECL can be applied in situations first when the parties explicitly agree in their contract to incorporate PECL or have a contract governed by them. So this demonstrate that their clear intention to use PECL principles as a legal framework for their agreement. Second is if the parties agree to be governed by the general principles of law or similar concepts like lex mercatoria or a set of international commercial law principles, the PECL might be used as a reference point by the courts or arbitrators to interpret the contract. So this is because the PECL represents a comprehensive set of principles for European contract law, and it can be a reliable source for understanding the broader legal context. And third is in situation where the parties haven't specified any governing law for their contract, the PECL can potentially apply if the contract has a close connection to the European community. For example, one or both parties are Europe-based or their subject matter significantly relates to the Europe, or when there are no other applicable legal system. Next is the freedom of contract. So under Article 102 of the PECL, it deals with the principle of party autonomy. So it means that parties are generally free to determine the content of their contract as long as it doesn't violate to the mandatory rules. So for example, setting a price, quality, and delivery terms. On the other hand, Article 103 of the PECL address the limitation of the freedom of contract by mandatory rules. So this means that despite of the principle of party autonomy, there are certain rules and provisions that cannot be contract out, and these mandatory rules must be followed regardless of the parties' agreement. So, for example, with regard to consumer protection law or to the product safety standard based from the jurisdiction of the forum state that were both agreed by the parties to settle disputes. Last paragraph states that choosing PECL can potentially avoid the application of a certain national ordinary mandatory laws. So, where ordinary mandatory laws refers to the national regulations that applies only to a specific jurisdiction and can be overruled by choosing different governing law. So, for example, the law that governs with regard to the terms and conditions of the contract, which is opposite siya sa directly applicable law, which is a fundamental national regulations that always take superiority irrespective of the chosen governing law. So for an example, is like kagina, ang consumer protection law, ang public policy, or the competition law. Next is the formation of the contract. So according to the paragraph 1, PECL acknowledge the rights of the parties to enter into a contract and establish the terms through their mutual agreement. So a binding contract is formed only when the offerer receives acceptance from the offeree. So this signifies that there is a meeting of minds between parties regarding to the contract terms. According to the paragraph 2, like man sa CISG, if the offeree or the receiving party expresses agreements to the offer but introduces changes to the terms, it is generally considered a counteroffer. But minor alterations that don't significantly impact the core aspect of the agreement is not considered a counteroffer. So only substantial changes and alterations in the essence of the original offers, such as the significant price increase, the changes in the quality and the quantity, the delivery terms, constitute a counteroffer. So PECL also emphasizes the need for a fair and honest negotiations throughout the offer and counteroffer stages. So in good faith, malinis ang intensyon kag wala pan daraya. Lastly is the remedies for non-performance or breach of contract. So just like man sa CISG, the available remedies for non-performance or breach of contract includes specific performance, termination of contract, reimbursement of damages. But also included here sa remedies available is the reduction of price. So where the aggrieved party can claim a reduction of price when the delivered performance is faulty or incomplete. There is also an exemption for the breach of contract where the remedies for the reimbursement of damages and specific performance are not admitted. This is due to an impediment beyond the control or the unforeseen event beyond the control of the party, which renders the performance impossible. So this excuse or the impossibility to perform lasts as long as the impediment persists. So once the impediment is resolved, the contractual obligations resume. So in cases of hardship, the aggrieved party has the right to negotiate the contract where both parties can attempt to change or to adjust the terms according to the changed circumstances or to request contract termination.